So what happens with the Chief Justice's interpretation of sex into the Constitution to mean sexual orientation? Does that stand, or is that challenged?
That is that.
Okay. So what is the significance in your minds as the litigants and the attorneys to this decision of the Court of Appeal to this matter?
Certainly it's a stamp of approval, not only on the Chief Justice's decision, but all decisions that have been coming out of other Commonwealth countries, that it is not acceptable to discriminate on the basis of sexual orientation, and laws such as these, which inhibit consensual, adult, same-sex intimacy, is not constitutional. So it was a stamp of approval on that to me, and it certainly progressed further that this sort of behavior of states cannot operate in this day and age, and certainly uphold the Constitution and the rights of every Belizean. So that's one of it.
Is this the end of the litigation related to Section 53?
But one cannot ever say that. There are other parties to this case. The Attorney General, if not pleased with the decision, may decide to appeal. So I can't say that. We are evaluating the judgment ourselves, and so can make a decision, informed decision later on. But I cannot help but the Attorney General.
The actual language that the court wrote into Section 53 and the interpretation, those stand, you have said, do you know if those have actually been amended by legislation?
So, but with the first order of the Chief Justice was that the law contravened certain provisions of the section to the extent that it applied to persons, and the Court of Appeal upheld that. They had some difficulty with something else that the Chief Justice did, but the first thing is that the law is void to the extent that it applies to Mr. Orozco and others.
Okay, so there was no need to actually rewrite.
If the Court of Appeal was of the belief that he didn't need to write an opinion, that the first order was sufficient, and that's what it was.
Okay, Senior Counsel, if I can direct this to you and Kayla as well. At the time of this original decision in 2016, there was a lot of uproar, as you recall, a lot of threats back and forth, and I know you were under pressure, if you will, and so was. Here, let me start to see, one by one, the Catholics and the Anglicans and eventually the Evangelicals drop out of this matter as interested parties. Do you find it significant that at the end of the road, as of today, only the government is appealing a decision that, in truth, they had said at the time, did not really find much in it to be contrary about?
Well, the government really made an appeal that was very limited in scope. If you recall, Mr. Hoff in court drew the attention of the court that the appeal from the government was not against the decision that Section 53 of the Criminal Code violated the Constitution. They had problems with two links. One, freedom of expression, which is the Section 12 of the Constitution, and Section 16, in which the Chief Justice said that the definition of sex as a basis for not discriminating against persons, that definition included sexual orientation. What the Court of Appeal has now done is to reaffirm the Chief Justice's decision regarding freedom of expression, Section 12, and have said that if you are not able to legally express your identity, your sexual identity, if you are not able to have sexual intercourse with a consenting adult of your choice in privacy and all of that, then you are being hindered in your freedom of expression, and that should not be allowed to be so. So they've also said that in their minds, the definition of sex does include sexual orientation, and one of the ways that they explain it is that included in sexual orientation is the expression of how you express your sexuality. And so therefore, to their minds, the Chief Justice's interpretation of sex was consistent with the basis for non-discrimination, and that a definition of sex could include sexual orientation, so they've actually affirmed that. So what it means is that at the end of this decade, we now have two of the highest courts in the land in Belize affirming that the criminal code is wrong the way it is written and should not be allowed to stand in terms of consenting adults and their sexual expression, and two, that you are not permitted to discriminate and you're not permitted to derogate from someone's freedom of expression in this way. To my mind, the next fight and the next uproar will be over the issues that come up in the new decade having to do with things like identity and marriage equality. But that's as far as I can tell you at this point. If you're using my crystal ball, I'll tell you that's the next frontier.
Okay, I guess what I'm getting at here is,
In answer to your question, I could, I think something that the court of appeal said kind of answers your question, which is that the rights that are expressed by Mr. Orozco and other persons in the LGBT community does not offend the rights, the fundamental rights of others. Yes? So even though they can express themselves in a way in which they do and have sex with whom they have, while it may offend other persons' senses and morality, it does not offend their fundamental rights. And so I think that is an acknowledgement, as you were seeing with the community themselves, that they are now becoming and understanding more that this does not take away any of their rights if Mr. Orozco and other persons in the LGBT community exercise their own rights. And so I think that's an acknowledgement that that's why you don't see the same sort of uproar that was then back then.
okay, well, okay, but just to complete my question, I was essentially asking, was the appeal necessary? And I gather from what you're saying that the court found that it is necessary to clarify what you said in relation to these rights, while maybe offensive, it does not take away from those others.
The universal push for LGBT is to eventually get married to each other, and that's matrimonial sanction. Do you think that will extend, this judgment will extend to that?
So first of all, I'm just saying that that's not what this case
It's about
was, right?
No, but
That's
I'm
not what
saying
this
that
is.
the universal approach or the universal wish for the LGBT folks is for them to eventually get married to each other.
I think that's a completely different kettle of fish, which, but
Maybe I can answer that. I think there are two parts. One of the things I learned with the litigation is that part of it is legal, but part of it is political advocacy. When you learn about, there's so much to tell as to what is happening behind the scenes. You don't have time now. But what I will tell you is with the decision in 2016, the sky did not fall on the population that opposes us. And once the population realized that the sky would not fall, elevate citizens. As citizens, we are on the front line of defending the democratic institutions that we create to uphold the human rights of other citizens. LGBT, marginalized women, a person with diverse ability, a person experiencing domestic violence, you have the ability to take an issue to court and get redress. But what's clear in this process is that even with this decision, I'm quite clear that the Attorney General Office will not get up and automatically start revising laws based on this decision. The way law reform works is that the Attorney General Office gets instruction from Cabinet, but before you can get instruction from Cabinet, there's something called a Cabinet note that must be written, and a champion must take that Cabinet note to Cabinet for approval before anything happens. It would be my hope that with the decisions on equal protection under the law and equality, that the Attorney General Office will be inspired to consider looking at revising the various laws that promote inequality and dishonors the ideal of our Constitution, which speaks to the idea that we all have equal protection under the law. So that is my hope. Now what we know is that further advocacy has to take place to one, to do the basic things like amending Section 33 on paper, continuous monitoring on what the ideals of our Constitution is, and examine the enforcement mechanisms. And three, getting users of the system to be inspired enough to stand up for themselves when their civil rights are violated. This is not the end all or be all of the decision. This is just halfway through the book. What we don't realize, whether you're one side of the coin or the next, is that as citizens, our civil rights are always under attack, and that we must be vigilant in being able to defend it wherever necessary. It is my hope that for other groups, that they can take a lesson or a note from all of the work we've done and build upon it. Because the work of civil rights is not just an LGBT issue. It's an issue for all of our citizens who are concerned with things like stop and frisk, hold and release. These things have not been tested, but they are civil rights issues of the day that are evolving because we have not understood fully. The state does not have an automatic right of sanctioned violence, discrimination, or indifference in protecting its own people.
One side thing is that in the Constitution itself, Section 16 is specified to not apply to marriage.
If you ask me, that's the next frontier. And it's one simple thing. When we started this process, I was very clear that when it comes to human dignity, that it is critical that we understand that whether you are LGBT, whether you are a person with disabilities, whether you are a person who is of a different ethnic origin, all of us have human dignity, and the Constitution states very clearly that we have inalienable rights that cannot be taken away from us because they are given to us by our Creator. And those aren't just words, those have meaning. The two decisions, one from the Supreme Court and one from the Court of Appeal, affirm that that is so, and that those rights cannot be taken away from you in a law that violates your fundamental rights and freedoms. And if the law tries to do that, then you have every right, as Caleb has done, to go to court and to fight against that law. And so, in as much as persons who are LGBT or intersex wish to do the normal human thing of linking themselves in a union, I think that is going to be the next frontier, and it is for those persons to take up that challenge. But I foresee that challenge coming, and it's not just that. The other issue is identity. Transgendered persons. What do you do in terms of identity? Can you have yourself legally declared as one gender or another? And those things are all things that are coming in the world, and they are happening. Belize is not going to be any different. But I think we all take a great deal of pride in the fact that not only did Caleb step up to challenge the legislation, but that he has stuck with it for what is now a decade, and that not one, but two courts have affirmed that he has the right to his expression, to his freedom of expression, to his privacy, to his equality before the law, and that those rights cannot be taken away from him, not even by an English law that we inherited, and that for some and in some countries is thought to be unchangeable.
I know, Ms. Schumann, I know you said that you're looking into your crystal ball that marriage equality might be one of the next big,
Frontiers,
yeah,
yeah.
next big issues that will come to the fore. Are you speaking with any foreknowledge that one such challenge has started to
No
emerge
challenge
yet?
has started, but I think, or rather I should say, it is my opinion that it won't be too long before it is challenged. Because I do know there are Belizeans who want to have the same opportunity that you and I have of being miserable in a civil union. So that is to come.
Yes,
Yeah, I
not
see.
this case.
I saw
Not this case, but it's coming.
I saw that you had a comment to add, Caleb.
Yes. One of the things I learned is that we're concerned with poverty in this country, but we're not recognizing certain principles that you give people a choice to access benefits. You don't deny them that access of benefits. When it comes to the issue of dignity, you give people a choice to decide whether they want to access a health facility or whether they want a person who's non-blood to decide their life or death health decisions, or if they want that person to compete for them. It's as simple as that. For me, marriage equality, yes, is the next step. It was never the original intent when we started. But when I realized that those people are married in Mexico, the state of Cancun, for example, or marrying in London or New York, it is the next conversation in cementing a relationship of security. For us as a community, relationships are about psychological and economic security. It's as tangible as you sharing a light bill and a water bill. And so it is not controversial. I also agree with Lisa on the point. We should be given a choice to be as miserable as everybody else and pick up a challenge. Or we should decide not to be as miserable as everybody else and live alone. The point here is that as citizens, we are given equal treatment under the law, and that our choices are not segregated because of the perceived will of a few in the hierarchy of power or the silence of my own community. For me, the silence of my community does not mean they give consent to their mistreatment or their unequal treatment under the law. It just means that it's a place for discussion, change and transformation. And that's where we're going as a country.
If I
sorry.
could extend on just that point, sorry.
Go ahead.
Afternoon, everybody. Yeah, for those people, myself included, who might not want to engage in the misery that you speak of in seeking matrimonial rights or whatever it is, but there are people who are in common law unions. For us, it might not be as clear-cut, and the reason why I bring it up is because the last time I attended the Social Security conference or briefing, I asked a specific question. Whereas for quote-unquote normal couples, heterosexual couples who are in common law union, so if the husband dies, the lady or the wife or the common law wife can claim his benefits. But in our case then, if we now go to the altar or going to the courtroom and say, I do or whatever, I will, but we're common law unions, we're people in common law union, how?
Right, except that the status of a common law union is badly understood in Belize. There are not any two people where they live together that common law. To begin with, in a common law union, neither party can be legally married to somebody else. So if you live with somebody's husband, you are not a common law wife, to begin with.
Right.
But also, the status of common law union does not occur until you have lived together in that exclusive union without being married to anybody else for 5 years. So that even on the Social Security, men and women not married to each other but living together in an exclusive union for 5 years have rights, but they have rights because the law says they have rights. And insofar as that is concerned, the law still restricts that to a man and a woman. Okay? So those are kind of the legislative changes that will occur. But I also see some scope for a heterosexual couple to decide to challenge either the Marriage Act or the laws related to common law unions, to then say, if you will permit a heteronormative couple to have these rights, but you will not permit homosexual couples to have the rights, that is discrimination under the Constitution. And that's why I think it's the next frontier. It's the next logical step.
So I was just going to mention that in terms of misery in marriage and so on, that's really what you put into it. As a couple, and
that's a light commentary, but let's put it this way, as Caleb said, there are social security benefits. There are benefits for children. There are rights when you go to the hospital and you cannot speak for yourself. As estates, there are rights for estates. The right of who survives and who gets to apply for your estate if you haven't done a will. All of these things are complicated. The state recognizes marriage for one simple reason, to regulate among people what are their rights and their benefits in terms of each other, but also in terms of their children. Marriage as a sacrament is a church thing. That's not what we're talking about. None of this is going to change that for the churches. The churches will decide who they marry or who they do. This is in terms of the state and the civil rights that flow from such a union.
Okay,
But just
so
to be clear, again, that's what you're saying is that that's not what this case is.
No.
But I
think we're all very clear.
I think we're very clear about that now.
That's
So,
not what we are pleading in here.
yes, that's for the reminder. Now to turn to, I know there is a briefing scheduled for this evening amongst the community, and you spoken, of course, of continuing activism and so on. You said earlier, Caleb, that the community has been mostly silent, which is, as you said, not consent. But does this signal a change? I know we spoke a couple of years back about some domestic abuse cases that ended up in court, and that was hailed, at least in some quarters, as a change as progress, yes. Does this help to further cement the community's belief in trusting the state to deal with these matters, of course, pending all the various litigational changes and so on?
Confidence in state system remain low, and that level of faith in the system is as a direct result of what my community have experienced in the community itself and among family members. Expecting whether we will perceive for state services to be as discriminatory in delivering service as everywhere else. With that said, what this case has done is shown a pathway for any person concerned with a proper treatment when accessing state services, be it health or justice, to expect some level of dignity in the way they're treated. And that's important because now we have a few more leaders working on specialized issues. Trans rights, for example. Another specialized issue is LGBT family, for example. Another area of expertise is that we have evolved into development of a human rights observatory that looks at marginalized women, that looks at persons with diverse abilities, that looks at LGBT persons, and looking at the broader issues of gender and developing systemic change that supports the prevention of victims who are experiencing violence or inequity in the system. I think that's an important framing, because none of this would have happened without the start of the litigation, or none of this would have been inspired in its development without starting this litigation. That's an important point. Another important point is that when I started, it was my face 24 hours, 7 days a week. Now you can turn to a few more people to organize community events. And we're collectively working to build a spirit of action and collaboration and organizing that was never there before upon the filing of this case. I think those are important milestones for our community to now have individuals ask themselves, what are the possibilities of action and change they can bring as individuals to the work? And what is it that they're prepared to do to stand up against us? We know that the study in 2018 for men versus sexual men points out there's an average of 9,800 plus men who are sexual men versus a higher form, which is about 15,000. And what that says is that we come with a consumer buying force. We come with we exist as a political bloc. We are more than just our bodies. We are more than just Section 53, and that we're looking for our issues to be visible in all aspects of society, and we're working towards cooperating with other groups to ensure that quality of life is grounded in how we're governed and how we're treated as citizens.
Good, guys. I don't see any colleagues lining up for more questions. We're good.